Hello, and welcome along to Protected Conversations, a webinar that forms part of EW's for the HR Manager series. My name is Rachel Lamsley, and I'm a Senior Employment Law Advisor here at Ellis Whittam. Today we'll be discussing protected conversations and how these can be used in your business. In today's webinar, we'll take a look at what is a protected conversation, what's a settlement agreement, when should you avoid using a protected conversation, what's considered inadmissible and undue pressure, what we can help you with here at EW, and finally next steps. So what is a protected conversation? This is found under section 111A of the Employment Rights Act, and in a nutshell is a confidential offer and negotiation to terminate an employee's employment. In order for this to be formalised, it requires a settlement agreement to be signed by all parties involved. But what is a settlement agreement? Well, there might come a point when you feel that there's no alternative but for someone to leave your organisation and you want to consider having a clean break. This can be the answer to all sorts of situations, as it can lend itself to a quick and less painful route to terminate somebody's employment with you. But as with everything, there are always a few considerations when deciding to offer a settlement agreement and have a protected conversation. Firstly, ACAS gives us a real neat definition of what a settlement agreement is. That is, that settlement agreements are documents which set out the terms and conditions agreed by those involved. So in the case of an employee and employer, those are the ones that sign the agreement. In the agreement, the parties agreed to settle any employment tribunal claims or other court proceedings. What's worth bearing in mind is that in a good number of settlement agreements, there is a financial incentive for the employee to sign the agreement, or at the very least some form of payment in return for entering into the agreement, for example a reference. Once agreed, settlement agreements are legally binding, which means that they can waive specific employee rights such as unfair dismissal. In order for that to be binding, an employee needs to take independent legal advice on the agreement itself. Do remember, these agreements are voluntary, and in most situations, the negotiations are confidential, which means that they can't be relied on or referred to should you end up in front of a judge. However, as with all of these things, you need to make sure that you're taking the right steps in engaging in protected conversations. When you engage in a protected conversation, you actually get off-the-record status, which means that those conversations can't be relied on later on in any proceedings. However, we shouldn't have any sort of protected conversation where there is something perhaps that will lend itself to automatic unfair dismissal. We should also consider if there are any potential claims for discrimination or for whistleblowing, as in any of these cases, a protected conversation won't be off the record and can be relied on later on in the proceedings. You do need to take advice when embarking down a protected conversation, as you want to ensure you preserve that off-the-record status. Therefore, if there is any risk of automatic unfair dismissal, discrimination, or whistleblowing, you might want to consider having a without prejudice conversation, which is something we'll talk about in a separate webinar. So, what is considered inadmissible? If none of the issues arise that we've just talked about in terms of automatic unfair dismissal, discrimination, or whistleblowing, the conversations that happen pre-termination are considered off the record or inadmissible. It's therefore really important to make sure that any conversations are held in this protected conversation remit. There are some flags, though, to look out for. If there is any undue pressure put on the employee, any improper behaviour or bullying and intimidation in order to enter into the agreement, then those conversations will lose their off-the-record status and the employee will be able to refer to them later on in potential proceedings. So what does undue pressure look like in reality? Well, this could be not allowing 10 calendar days to consider the offer, which is a requirement under the ACAS practice code. It could be that you reduce the offer in the 10-day period, or saying that the dismissal is inevitable. Finally, threatening to undermine the employee's public reputation is also considered undue pressure. A few things to take away with you in respect of settlement agreements generally. Firstly, the timing of making a settlement agreement offer is important. If a settlement agreement falls apart before signing on the dotted line, employers really need to consider what impact this will have on the continued working relationship. It may feel somewhat awkward having to work with someone who you've just indicated to that you want to terminate the employment relationship. Whilst a settlement agreement can be offered at various points in the employment relationship, they are voluntary negotiations after all, and so are not necessarily a surefire way to terminate the employment relationship. So what do we help you with here at EW? Well, first and foremost, we help you identify the right time to make an offer of settlement. We give you a hand with drafting the offer letter and the settlement agreement, as well as advising you on the right to be accompanied at the meetings. Guidance on the timing of the offer and when to put this forward is obviously key, as well as guidance on the value of a possible claim, all of which we can help you with. Using a protected discussion and having a settlement agreement can be an excellent tool to get a business to where it needs to be quickly. And so if you're considering this option, I would suggest that you work through all aspects with your advisor before commencing any conversations. We assist our clients with this every day as part of your service here at EW, and we draft the agreements for you. As experts, we really can help you set off down the right route. So, in terms of next steps, if you are considering having a protected conversation, you might want to consider first why you're bringing the employee's employment to an end. Consider if there are any risks, such as discrimination, whistleblowing, or automatic unfair dismissal, when having a protected conversation is really not suitable. And finally, before cracking on down that route, do make sure you take advice. To find out more about our For the HR Manager series, do get in touch at inquiries@elliswhittam.com.